All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV16-0690. Frank PICCIOLI, sorry, versus City of Phoenix. And of course that involves many other individuals and plaintiffs, but for sake of ease of reference. Counsel, remind you both that these proceedings are being video and audio recorded, so I'd ask you to please let us know your names and who you represent at the beginning of your arguments. Each of you will have 20 minutes in which to present your arguments. Both of you, because there is a cross appeal, if you'll each reserve as much time as you would like for rebuttal. We won't remind you of that time, but if you want to sit down when you're ready, and you can have the rest of the time for rebuttal. Also, please keep in mind we've read the comprehensive briefs and have discussed this case in conference, so please keep that in mind with your remarks. With that, counsel for appellant, you may proceed.
Good morning, Your Honors. May it please the Court. Eric Frazier on behalf of the City of Phoenix, Copers, and the Copers Board. I have with me at counsel table Haley Crawford, and Brad Holm, who is the City Attorney for the City of Phoenix, is in the courtroom as well. I'd like to discuss the two of the fundamental components of this case. The first component I'd like to discuss is a question of statutory construction, which is whether the city charter permits pension spiking. The second component I'd like to discuss is whether the city can fix, prospectively only, the mistake it made by allowing pension spiking for many years. On the first point, which is statutory construction, the biggest clue we have in how to treat unused sick leave for pension benefit purposes comes from the charter itself. The voters decided that unused sick leave counts as credited service, which is the time factor in the pension benefit formula. And because the voters already decided how to treat unused sick leave, we should respect that decision rather than trying to shoehorn this concept into the terms salary or wages. It's also important, Your Honors, to differentiate between two different concepts, between sick leave itself and the concept of one-time lump sum payouts at retirement of unused accrued sick leave. So sick leave itself is something that you accrue every month. You can use it in any month. When you use it, you get paid that month. It's designed so that if you're supposed to make $50,000 a year and you get sick, you will still make $50,000 that year. The one-time lump sum payouts, on the other hand, are very different. It is a lump sum payment. You get it only once. It's the type of payment where when you get it, you go out for a steak dinner that night, right? You cannot get it every paycheck. You cannot get it every month or even every year. It comes literally once in an entire career. So that means it's not part of your regular periodic salary or wages. Now, the members really conflate these two concepts, but it's important to disentangle those when you're reading through the case law in this complicated area. The problem with basing pension benefits on these one-time payouts that happen once a career at retirement is that it results in much higher pensions than you would have if you treated the unused accrued sick leave in the time component, in the credited service component of the pension benefits as the voters intended.
Counsel, so we're looking at plain language, salary or wages. It's my understanding, and Judge Brain hit on this point on page 30 of his ruling, and opposing counsel referred to this several times, is the fact that there are other aspects, other components, if you will. I'll read a few. Vacation payouts, holiday payouts, tool allowance, overtime pay, show-up time pay. Help me understand, A, are those being included in final average compensation currently? And B, is it the city's position that they do fall within the definition of salary and wages? And C, how do you distinguish those from what we have here, sick leave payments? Sorry.
Sure. No, that's a lot of questions. So I'd be happy to address as many of them as I can remember. So, well, first, many things have changed, and I'd like to bring to this court's attention. There's a companion case that's pending in this court right now. So I'll give you the case number. It's 1 CACV 18-0027. That's pending in front of this court. It involves similar issues, similar parties, the same lawyers. The court denied a motion to consolidate, but we want to bring it to your court's attention because it's directly relevant to the question you just asked. That case involves an action that the city took after this case began, which essentially said that one-time lump sum payouts for accrued and unused vacation leave no longer count as pensionable compensation. So vacation leave was in your list. That has now changed. Vacation leave payouts, the lump sum payouts, are no longer included in pensionable compensation. There are other items in your list that are no longer included in pensionable compensation. And frankly, as Judge Brain said, and Judge Brodman, he was the trial judge in the companion case that I just mentioned, as both judges recognized, once we get guidance from this court or further appeals on what counts as pensionable compensation, we might see further changes. So if there are particular items on your list, I'd be happy to discuss them. The items that we view as part of pensionable compensation are the items that are normally part of your periodic regular payments. So items like the one-time lump sum payouts for sick leave and vacation leave, those are excluded. Certain items that are in your regular paycheck on a regular and periodic basis, those are included in your pensionable compensation under our construction of the charter.
And that's based upon your view that wages and salary, although I think we have to, give those the meaning that we interpret those to have separate meanings because we have to, and they have separate meanings. But in both those, they have to be periodic, systematic, regular, recurring. Is that the city's view?
That's right, and also the language in the charter about the annual payments. So we have the dictionary definitions of salary and wages, which all have the concept of these regular periodic payments. We have the concept of annual payments in the text of the charter. So that's right. We also have cases like Cross v. EORP, where in 2014 this court held that these one-time lump sum payouts are not part of pensionable compensation. That was about salary. And cases across the country, International Association of Firefighters versus Kansas City, Craig v. City of Huntington, Stover v. Retirement Board of St. Clair. Those are from Kansas, West Virginia, Michigan. All of these courts held that these types of one-time lump sum payments are not part of pensionable compensation, as distinguished from the kind of regular vacation leave or sick leave that you get when you miss a day of work. It's these
let's talk about, was it 17 or 16 years of uninterrupted practice where we had this accrual? I think it's your position that practice violated the charter. Is that correct?
That's right.
All right. So 16 years of that practice. My question relates to what is, I think you described it as sort of your compromise, which is you're going to continue to provide this accrual to a subset of folks' grandfather. And so let's take a look at that. How do you square that with your foundational argument that that's illegal? And what is it that provides you with the authority to say, yes, it's illegal, but ellipsis, fill in the blank?
Right. Well, we tried to do what was the fairest and most equitable thing for our employees, something that balanced our obligations under the city charter to honor the text of the charter and what the charter defines as pensionable compensation, while also recognizing that we told employees and members for 16 years that they could engage in this pension spiking process. The members are not challenging the legality of the first half of your question, which is our authority to permit pension spiking going forward for items that the members had already accrued. Right. And
well, let me follow up then. Okay. So fairness apparently is sufficient to defeat, in this case, specific instruction of the charter. Is that what you're saying?
That's not what we're saying.
Well, then what? Okay, let's go back. What is it that gives you the authority, given your base argument that this is illegal, to grandfather those folks in?
Well, first of all, the sick leave that is grandfathered in has already been earned, and so therefore it is already vested. So there's a distinction between what was vested and what was unvested, right? Under the Bennett,
Cash would be vested. The cash, the payment, the cash payment. They have their.
No, the sick
When
leave
they
that
retire, they're entitled to. Help me understand the policy. When they retire,
Yes.
it would be 5 years from now, whatever. For that time period, prior to 2012, they're entitled to get the cash payment for the accrued sick leave.
Yes.
At retirement.
Correct.
But what's not clear is that I think where we're getting at is what's the legal basis to allow them to bump up the pension amount through that, through the payment, through the cash payment at that time, when the city's position is it's not legal. It's not legal to do that.
Right. Well, certainly, Your Honors, if this court concludes that our snapshot approach, the first half, is unlawful, then we will stop. But that is certainly not the contention of the members. And we think that if we had not grandfathered in the sick leave that had already been accrued, we would have faced serious litigation over that as well. And so we thought this was the most equitable way to address the problem, particularly in light of the provisions of the charter that allow us to correct mistakes in the most practical way possible.
Okay, so you concede that's illegal.
Our snapshot approach?
You're sort of grandfathering.
No, we don't concede that that's illegal. Under cases about what has already vested, we allow what has already been vested to be treated the way to be treated under the policies that were in place when it vested.
So we're talking Yeasel now. Is that right?
Well, no, Yeasel and those other cases talked about changes to the actual plan terms. So we don't think we're even in that universe.
Well, if you don't mind, let's transition to Yeasel a little bit, because this to get down in the weeds in it. So, if I understand correctly, the employees are asserting that for the 16 years, I mean, there was developed, for lack of a better term, a custom and practice and system put in place where everyone knew. It was in handbooks. It was in PowerPoint presentations. It was the city council was on board. The retirement board was on board. The city manager put this out there as well. Everybody knew it was that. That's what it was. How does that not become a part of the Yeasel, what I'll call the Yeasel contract, which means basically these employees had a contract and the city essentially amended that? What's wrong with that position? I'm not seeing a lot of weakness in that position.
So the Odin case from California rejected a position that is even stronger than that. Odin essentially held that even express collective bargaining agreements cannot alter the plan terms as defined by the voters or the legislature or what have you. Past practice and those collective bargaining agreements cannot trump the plain terms of the charter. Otherwise, that would leave pension benefits up to the decisions and statements and errors of government administrators. They could promise employees more generous pension benefits than you're allowed under the plan, and then somehow those would be locked in for the remainder of the employee's career and for the remainder of the employee's life. But you cannot make these kind of side contracts that give additional pension benefits.
At least a handful of courts have done that. Washington, New York, there was a couple others I think cited in the briefs. What's your position on that? I mean, what was the Washington Supreme Court, just nuts when they did that, or what?
Frankly, yes, and especially when you consider that Arizona has stronger constitutional protections for pension plan benefits, that if you follow that Washington court, the Bowles case, that would allow essentially what I just described, where you have government administrators saying, you know what, we'll create a new policy where you can save up 50% of your compensation and get it paid out whenever you want. And so, of course, everyone will choose the 3 highest years and get it all paid out. And that would allow government administrators to completely sidestep step, the careful plan terms and plan documents that control pension benefits. So we have this system where we have Yazelle and the pension clause, where Arizona's constitution and case law have a very severe ratcheting system, right, where pension benefits go up and they can never come back down. And we're not disputing that system. But that system, for this system to work, that ratcheting system can only apply to actual changes to the governing plan terms. If we allow government administrators to make side deals or side promises and invoke that very severe pension ratcheting system, the system just doesn't work. That would allow government administrators to disregard voters' wishes in this context, to disregard the legislature's wishes in plans like ASRS, and would allow these kind of side promises for more generous pension benefits.
On that point, what's your opinion? What is the meaning of public, under the pension clause, public retirement system benefits? What does that phrase mean? First of all, is it plain?
In the pension clause, you mean?
Yes. Is it plain and is it unambiguous?
Yes, it's unambiguous, and no court has ever construed that term to mean anything other than the governing plan documents.
What does it mean in your view? What does it encompass?
It encompasses the governing plan documents, like something that the legislature puts out, something that the city voters vote on in the COPER system, something that actually controls the plan terms.
So it's the city's view, just to summarize, if I understand you correctly, the city's view, nobody, no entity, no person, no body can amend or change this retirement plan, COPERS, without city voter approval.
Absolutely.
Unless it has vested.
There are certain, that's, even if it's vested, those still don't become part of the plan terms, right? But we may have some equitable reason that we need to honor previous commitments for things that have already vested. But those don't become part of the plan terms, and those don't become, ratcheted up for life.
So let's be clear. An administrator for the city says, come on board, join us. We got the best thing. We got this accrual you can stack, pension spike. It's in the documents. Just come on board, and that employee sort of considers their options. They forego one option, and they say, that sounded a little too good, and they go with you, and they leave everything else aside. Sounds to me like the state could just say, just kidding.
Well, certainly for under our framework, anything that the employee has already earned or already accrued would be grandfathered in. And under the Bennett and Abbott cases, employees don't have future rights to unearned things like unearned sick leave, unearned vacation leave. And so these employees don't even know whether they will get sick leave in the next bargaining agreement, or how much they will get paid, how much sick leave they will get. These things can all change. And so under our framework, we would grandfather in everything that they had already accrued and already been vested in based on that kind of reliance. But future benefits, which have not vested yet and have not accrued, would not be bound by these side deals that deviate from the governing plan documents.
And that's the compromise you're talking about.
That's the compromise we talked about. That's the snapshot approach.
Which is legal.
In our view, it's legal. If you tell us otherwise, then of course we'll act accordingly. But in our view, that's legal, especially given the Charter's provision that we can correct mistakes in a practical way.
Well, just to clarify, the parties have now briefed the legality of the compromise.
Well, we haven't briefed the half of the compromise that.
Sorry, I'm not the 2012 AR that stops the practice is what's being litigated here.
Yes. And that 2012 AR includes the snapshot in its provisions.
So what if vesting is the critical point? Let's say at the outset we have some oral assurance of vesting, sort of looking out. Guess what? You are vested entirely on day one on this promise. Does that change it? Does that make it legal? What was illegal? Because we're now saying it's vested?
I'm not totally following your question. Who's saying it's vested?
Well, you seem to be emphasizing the point of vesting.
Right.
As the stage at which you can continue to violate the charter or not. Is that accurate?
Essentially.
Okay. So let's explore that vesting. And let's say, could the city vest on day one, enter into a contract, you are vested for this, what do we want to call it, benefit, throughout the course of your career. Would that be legal or illegal?
That would be illegal, Your Honor. That contract would be ultra vires. It would be void. That's not the kind of thing that we can contract for. If the city voters, in establishing the charter and establishing the city of Phoenix, intended that administrators could enter into those types of contracts, they wouldn't have needed to create this very complicated and thorough system of COPRs, which specifies what's pensionable and so on. I'd like to reserve the remaining minute of my time. Thank you.
Counsel, I know we've asked you a lot of questions. We're interested in giving you a bit more time for it, but go ahead and add 4 minutes to each side, please.
Thank you.
Good morning, Your Honors. If it please the Court, my name is Susan Martin. At counsel table with me is Jennifer Kroll and Dan Bonnet, both of whom were at trial with me on this case. I'd like to just spend a brief few minutes on the definitions here, wages and salary, which were skirted over by opposing counsel. In plaintiff's view, there's no possibility that this court could conclude that those terms unambiguously prohibit the payments at issue here from being included in the retirement formula. First of all, wages, the term wages is universally considered to be remuneration for services rendered. We've given in our supplemental appendix, we gave the court multiple versions of Black's Law Dictionary and 8 other dictionary editions of different dictionaries, clearly making it clear that there is no regularity of a wage. You have day laborers who get paid wages. There's nothing fixed that has to be fixed about wages. But
let me ask you your definition that you just iterated. How is that different than from compensation?
Well, compensation is defined to include wages and salaries. That's what this charter does. And salary, if I can go to salary.
Yeah, but we have to read those terms as different.
Compensation is, well, the definition of compensation, which is the term used in the charter, is wages or salary for services rendered. Right. That is the definition. So finding that the payments are either wages or salary suffices to include them within the formula for calculating pension benefits. And plaintiff's view, there is no possibility that this court could find that the term wages, which is the way compensation is defined, unambiguously excludes these payments, since there's no possibility that those payments are limited to, quote, fixed regular periodic payments. Let me talk.
But that's essentially what Judge Brain found, albeit for a different reason. But
Judge Brain
found that the first sentence was not.
Judge Brain said it was obvious, but never explained how he discerned that. Let me just go back to the definition of salary very briefly, without dwelling too heavily on it. Salary was originally, in 1953, when this law was adopted, salary was generally considered to be remuneration for services. The distinction between salary and wages was to distinguish between what was generally professionals or clericals or officials, and those are terms that are used in blacks repeatedly, from day laborers, hourly rated employees. Those definitions said, in a more limited sense, and only in a more limited sense, was it a designation of a fixed periodic payment. And we've traced that from 1953 up through 1990. The Black's Law Dictionary definition of salary said only in a more limited sense was it fixed regular. It was usually professionals, and it was remuneration for services. So when the drafters of the charter, or the voters in this case, approved that, the generally accepted and widely accepted definition of wages and salary was remuneration for services, with the distinctions being who got paid and the form of payment, whether it was an hourly or annual. It doesn't matter, though, in this case, and let me explain why. It doesn't matter because in this case, all of the payments made here were wages. 2.441 provides for the payments of sick leave at retirement, accrued sick leave at retirement, on the basis of base hourly rates of pay. And when you describe a payment in terms of your base hourly rate of pay, you are not talking salary. You are talking wages. And the defendants have never established why people who generally get an annual salary can't also receive, in this instance, payment for wages. A lot of the payments that are received by Unit 7, and their contract is in the record, and they're the professional employees, a lot of their payments are paid on an hourly basis, on the basis of base hourly rates, which is wages. So if there was any concern about salary not covering this instance, the fact that it says salary or wages is amply sufficient. And that's really what we'd like to point out about those definitions.
Counsel, from 1953 until, when did the practice begin?
1996.
1996. Was salary and wages clear and unambiguous, and it certainly and plainly included sick benefits and accrual? So if I'm looking at that in 1953, is that clear and unambiguous to me?
Yes, Your Honor. We believe, because if you look at Black's Law Dictionary and if you look at the tracing of Black's Law Dictionary, which we thought was authoritative, it said, starting in 1953, or 1946, recompense or consideration paid or stipulated to be paid to a person, that's the defendants, at regular intervals, that's Webster's, for services.
So you're entitled to relief, if I understand you correctly, going back to 1953. Is that your argument?
We say that the charter since 1953, the terms wages and salary defining compensation are clearly broad enough in their clear and normal usage to encompass these payments. These payments did not begin until 1996. But overtime, vacation pay.
Was that important to the definitional point you're making? That the payments started?
Well, the payments started.
The payments were there. Was it clear and unambiguous that salary and wages included these prospective future payments?
I think it is clear and unambiguous if anybody had thought about paying for sick leave, but sick leave was not paid, accrued sick leave was not paid for.
What about vacation leave? Was it paid
vacation was paid for.
Prior to 96.
That's correct. At least we tried to argue that it was paid from 1953. The city doesn't really have very good records. The parties stipulated in the other case that it's been paid at least since 1981. Overtime, there's no question that it's always been included. Standby pay, call-in pay, merit increases. None of these forms or categories of payments are specified in the charter. They've all comfortably fallen within the rubric of wages or salary.
Are they all one-time payments paid out?
Some of them are.
Just some.
Well, some of them, a merit increase, for example, would be a one-time payment.
Retirement.
No, not necessarily at retirement. But, we cited the Morash case on that issue, Your Honor. Here's the Supreme Court of the United States in Morash rejecting the notion that because vacation pay was deferred until retirement, that it was somehow lost its character as wages or salary, as compensation. And the court very clearly there said, no, when an employee works extra time, as they did when they accrued vacation, when they could take the day off, or sick leave when they could take the day off, those are earned then. And the mere fact of deferring the payment to a later date does not change the character of the payment as wages or salary. It was wages or salary. The city received services, extra services, from the employees who forwent their sick leave or their vacation pay in order, to give additional service with the promise, with the clear and unambiguous promise that they would receive higher retirement benefits if the last year when these amounts were paid happened to be amongst the 3 highest years. Now, to turn to the issue of if it's ambiguous, Your Honor, if it's not clear, it's ambiguous, and then we apply the rules of statutory construction. And I've been joking with my colleagues that if they could speak, if the rules of statutory construction could speak, they'd be crying out in pain after reading defendant's brief, because they ignore or essentially violate every single one of those canons in making their argument. For example, it is indisputable that where there is a established practice, unless the court could find that that established practice was, quote, manifestly erroneous, then the court will apply the established practice in determining the meaning of the statute. And that is Long v. Dick in all of the cases that we cite on pages 67, I believe, of our opening brief. That the Supreme Court has reiterated recently, and there's no reason the defendants haven't attempted to distinguish those cases. Now they say, well, Long v. Dick doesn't apply because the parties agreed the statute was ambiguous. But you'd have to conclude that the city council, the mayor, the city managers, the attorneys, the employees, and the entire retirement board for 16 years acted irrationally in order to find that, there was no ambiguity that this was prohibited. I mean, I'm trying to establish a negative.
Counsel, let's move on from salary and wages to another definitional point, which is personal services rendered.
Yes.
Okay. It would seem to me that sick pay is almost the inverse concept, meaning you're compensating for personal services that are not rendered. How is that wrong?
Because this isn't sick pay. This is payment for accrued sick leave, which is no, it's not. It's exactly the opposite, Your Honor. When I take a day off because I've earned it, essentially, I agree. I believe I've earned it through services, but so I do think that the payment for that day is for services. But regardless, these are payments for days that weren't taken off. These are payments for extra services, not for not working, but for working when you had the right not to work. Those were extra personal services rendered to the city in exchange for the agreement that we're going to pay you that extra compensation when you leave employment, if you have. And by the way, they don't get paid.
Compensated twice for the same work is effectively.
No, they are not.
The personal services rendered, let's say it's drafting up a contract in the council's office on this particular day. That also, those services rendered were both for the wages earned for that day and for this sick leave benefit that is accrued at the very end.
But if I'm given a vacation day or a holiday or a sick day and I don't take it and I work instead of taking it, I have given you, the employer, more value than you have paid for, because I'm giving you, you've said I'm entitled to the day off. Now, if I work additional time, I'm entitled to additional pay. It would be like saying you work a 12-hour day, but we're only going to pay you for 8 hours because that's the regular rate of pay. No one would suggest that the extra service given by overtime shouldn't be compensated. They're working more. They're working more when they don't take a day off that they could have taken. And the city, by the way, instead of paying then for those services gets the cost benefit of pocketing that money that it might have had to spend for temporary employees or extra help or, transferring people out of title to do work. The city gets the benefit of that. It saves that money, which it then pays out.
You're saying the employee gets no benefit? Doesn't the employee get at least two benefits? The employee gets the benefit of the accrued vacation, of the accrued sick leave, by getting paid at the end of
That is a benefit, Your Honor.
That is a benefit.
Yes.
And the voters of Phoenix said, we're also going to give, in 1973, an additional benefit.
No, they don't get both, Your Honor. In 1953 or 19...
Well, okay.
In
alternative benefit. It's an alternative. It's
Yes.
not a benefit?
No, when the voters in
1973, the voters said that you get credited service.
That's
for your
correct.
or your
And if you
accrued
get
sick leave.
paid for the accrued sick leave, you do not get credited
The
service.
choice, but it's still a benefit for the employee to choose between those two benefits.
Well, that's...
Either the cash or how are we to read? It seems like you're asking us to read that out of the charter.
No, Your Honor, because...
Let me back up to statutory construction principles. We don't look at the term wages or salary in a vacuum.
Correct.
We don't just go look at 10 dictionaries or 20 or 30.
Agreed.
We look at the whole charter.
That's correct.
And what the city of the charter in 73 was amended by the voters in this way. Why didn't they say, okay, we're going to also allow you to increase the amount of the final average compensation?
Because no one was being paid for those days. The city had the discretion to establish its... No, but the city establishes its compensation policy. It was obviously to the advantage of
nobody was being paid, but the voters, who controls the pension?
They're not
here?
mutually exclusive, Your Honor.
This is the question. Do the city officials control the pension, or do the voters? It really boils down to that.
We're not talking about controlling the pension. We're talking about the compensation policy.
I'd like you to show me a case other than Washington or New York, who have actually said that a practice or policy can actually change the terms of the pension
Norton,
plan.
Your Honor. The defendants failed to even mention
that
the
changed
control.
the terms of the pension plan?
That was a case where the board that was delegated the authority to administer the, I think it was the public safety pension plan in that case, changed the definition of who could be in the public safety pension plan. That was the board. It wasn't a legislative change. The issue in that case was not just whether the employee who left and returned was entitled to the past service that he had earned. The issue was he entitled to continue to participate? And yes, of course he was, because even though the board changed its definition of who was entitled to participate in the public service pension plan, the court found that that employee had vested rights. Now, I think it's worthy of noting here that none of the categories of pay that are within the discretion of the city of Phoenix to pay or not pay, through negotiation, of course, are listed in the charter. Overtime isn't listed, holiday pay isn't listed, vacation pay isn't listed. None of those categories of pay are listed. Are we to say that the slippery slope we've already embarked on, that in 2012 it was accrued sick leave, in 2014 it was accrued vacation pay? Now what? Overtime and shift differential? How does the city, who has no authority to amend the terms of the pension plan, purport to assume the authority to reinterpret the pension plan mid-career? And that's why Yazell is important as well. Because
That makes this a tough case.
Because Yazell said your rights vest on the first day of employment when it comes to pension. You know why? I don't know why the court said that exactly, but we know that they did say that. This is a pension benefit. Pension benefits are accorded more sacrosanct respect in this state than other forms of pay. So we're not talking about a snapshot about sick leave. An employee, it's not about whether you can pay sick leave or pay vacation pay. It's about whether, when you do pay those things, are those payments included in the pension formula? So the snapshot is completely bogus. They have no authority because it doesn't compensate anyone for the loss of those benefits in the formula for calculating pension plans. I'd like to change to plaintiff's
Counsel, let me ask you.
cross-appeal, if I may, for a minute. Yeah.
Counsel, you said that the city should be held to their administrative practice. And they pivoted to that point, right? They weren't doing something, and then they said, we're going to let you accrue and stack it towards your pension, right?
To their benefit.
In 96,
yes.
right?
Yes, that's correct.
And now they want to shift back, and you're saying no.
Well, they can shift back for prospective employees, but they can't for current employees. I mean, and that's Yazell.
Right.
Yazell says, unless there's a consent here, you can't alter a promise to pay a pension benefit. This is part of the formula, right? The formula said final average compensation includes these payments along with holiday and vacation pay. The employees reasonably relied on those promises. In fact, the city, I don't know if you've looked in the record, the city handed out pamphlets and seminars how to increase your final average compensation. They encouraged and promoted employees, don't use your vacation pay, don't use your sick leave. This will increase your final average compensation. How do you change the rules of retirement planning in the middle of the game? I mean, they call it retirement planning because employees have to plan during their entire career of how am I going to support myself in my retirement. That's why Yazell says that right, your right to your pension benefit vests on the first day. Look at Yazell. Yazell had 10 years.
Should we get into your cross appeal?
Yes, please. Sorry. Our cross appeal. The court found that we had contractual rights under the Constitution and under Yazell to these benefits. We sued for preliminary and permanent injunctive relief. We were penalized for following the procedures followed by our esteemed colleagues Osborne in representing the retired judges in Fields. They sued for a preliminary injunction, asked that the case be consolidated with a trial on the merits, and sought class cert. That's what we did. We were shocked, actually, after a 7-day trial where the issue of consent was only about this 2-year contract that had already expired on the time of the trial. We were rather shocked that the judge limited the injunctive relief to 2 years. Once we established that our constitutional rights were violated, under Yazell, we were entitled to permanent relief, unless and until the city could come back at some point and said, you know what, these people, 10 years later, traded this for that, and they've consented to this change. That's not what happened here, and Yazell is very clear. They had the burden to introduce that evidence if they were going to argue that. Their claim in the brief, this is new counsel, by the way, their claim in the brief that the trial was about the 2012 to 14 contract. No, it wasn't. The trial was 7 days, which we were forced over our objection to participate in, to establish contract formation back in 1996 for 3 independent unions, and then to defeat their really sort of, in our view, meritless claim that anybody had consented. The judge found 179 findings of fact in our favor that this was a binding, enforceable contract. So with the court limited it to 2 years, he really violated, in our view, all of the provisions in equity that says if you're entitled to an injunction because there's a constitutional violation, you get full relief. You get it whether or not you even ask for it. You're supposed to get the remedy that's most appropriate. How could an unconstitutional provision be limited to 2 years? Court misunderstood, I think, the law on equity and injunctions, or somehow maybe misunderstood the fact that there's a collective bargaining agreement here, changed the law. There's no change here. Employees who are covered by contracts from certified representatives have the same constitutional rights in this state as employees who aren't. There's nothing about the existence of a collective bargaining agreement that would remove those protections from these employees. So the court, in denying that relief, we believe made an error of law. He also made an error of law in playing a catch-22 game with the plaintiffs, because we moved for class certification like the judges did, and we were told, no, it's not necessary because you can get all the monetary relief that you need at the end of this case, and aside from which the unions can be your representative. Then when it came time to order relief, the judge refused to grant injunctive relief to anyone other than the named interveners, and refused to grant prejudgment interest or remedy anything. He said at the fee argument, kind of walked that back and said, well, you can come in and it's a slam dunk right out of the box, offensive collateral estoppel, but that's not. Plaintiffs should be relegated to having to bring yet another proceeding to obtain their rights. So,
saying the permanent injunction should extend to the class, the entire class.
But the injunction should have been unlimited and should have applied to the entire group of employees who are affected. That's correct, Your Honor. You can't deny class cert on the grounds that it's not necessary and then limit relief only to the named interveners. That's a catch-22. And we think that that was an error of law. The court relied on those errors of law in determining to deny our attorney's fees. Also made additional errors in that denial, failing to, because our clients who are modestly financed labor organizations in the state put in declarations establishing that there would be a hardship in not providing attorney's fees or in awarding attorney's fees to the other side. So if the court had some criticism about us, and he did criticize our statement of facts from 2013, which, I mean, this was in 2016, Your Honor, and that was one pleading. If there was a criticism, he could have reduced the fee, but he should not have denied the fee completely. And he did it on the basis that we were only close call prevailing parties, when in fact we believe we were clearly the prevailing party.
Thank you, counsel.
Okay, thank you.
Your Honors, I'd like to address a couple of points. First, to follow up on a discussion that you had with me earlier this morning about the legality of our snapshot approach. If you read the Cross case, the Cross v. Eorp case from this court in 2014, in that case, the government tried to retroactively fix a mistake, and the court said that there was no pension clause right, but that there could have been an equitable estoppel claim. So the court remanded to see if maybe there was equitable estoppel that would prevent the government from going back and drawing back money. So that's part of why we acted the way we did. We did not want to face an equitable estoppel claim about things that had already vested, especially when Section 36.1 of the Charter, that's the reference I was searching for in my head earlier, gives the city the flexibility to fix mistakes in a practical way. I'd also like to discuss the discussion that you had, Judge Brown, with opposing counsel about what sick leave means and how it's compensated and why it's included as credited service under the Charter. So if we take a step back and just think about this big picture, consider two employees who make $50,000 a year each, right? And one of them gets sick, but one of them does not. The only material difference between those two people then is how long they worked. So one of them in the year might have worked 240 days. The other one worked 245 days. Because of the sick leave policy, they each take home $50,000, which is how much they're supposed to make. But one of them worked 5 extra days and so gave 5 extra days to the city. That's what my opposing counsel was emphasizing. But that means that they worked longer for the city, which is why under the Charter, you take those 5 extra days and you add them to whatever time you gave to the city. So if you worked 20 years, you now are considered to have worked 20 years and 5 days, right? The time that you worked when you could have taken sick leave but didn't is now added to your credited service, and it increases your pension in recognition of the fact that you just worked longer for the city. I'd like to address.
But that's not the case if you took the cash payment.
Exactly, right. I'd like to address just a couple of cases. The Massachusetts v. Morash case arises in a totally different context, right? It's about whether there's ERISA preemption. So there are lots of cases out there that involve all sorts of unusual circumstances. ERISA preemption, Wage Act, all sorts of things, or the purpose of having a really broad definition of wages and a really broad conception fits the purpose of that analysis. So in a Wage Act claim, for example, you want to make sure that every single penny that is owed to the employee is paid, right? If the employer stiffs an employee for a penny, the employee can come after the employer. That's a different concept from the defined compensation that we have when considering what is pensionable. Not every payment to an employee counts as pensionable. But if we didn't pay that, they would have a Wage Act claim against us. That doesn't mean that it's pensionable compensation. In the Norton case that counsel mentioned, that's from Arizona in 1986, that was interpreting a statute, right? A statute gave people the right to come back to work within 2 years and rejoin the plan. That is not saying that a practice or an administrative procedure can trump plan terms. It just can't. The bottom line is that the voters control what is pensionable, so the city can come up with new forms of payments to employees, but then you have to look at how that fits into the text of the charter. That's what we did here. We made a mistake, and we'll give the court a mea culpa that we made a mistake by allowing pension spiking for 16 years. We fixed it in a way that honors our commitment to the text of the charter while also being fair and equitable to the employees who were told they could spike their pensions.
Let me ask you, counsel, in these 34 seconds left. So what year was it that the voters voted and they said we will account for this service, but only as a matter of, I guess, the time component rather than what year was that?
That was in the 1970s, I think 1973.
73. Could they have, at that same time, have gone in the other direction and said, this is the time we're now going to say that sick leave can be accrued and accumulated as compensation for final pension purposes?
Absolutely. They absolutely could have. But we should respect the decision that they make. Phoenix was not only permitted to stop pension spiking, but was required to do so prospectively. We ask that you reverse the judgment. Thank you.
Thank you, counsel. Thank you both for your arguments and thoughts this morning in this case. We will take it under advisement and issue a decision in due course. The court is now adjourned.